Major breaking news, the National Association for Gun Rights was in a big fight in front of the United States Court of Appeals for the Second Circuit in New York City over Connecticut's so-called assault weapon ban, which is effectively a ban of certain semi-automatic firearms, specifically semi-automatic rifles, AR-15s, and the like. Major argument, we're likely going to lose it because we're in the U.S. Court of Appeals for the Second Circuit, but a strong showing for the Second Amendment in this case, and I think it's going to give rise to good stuff, hopefully, fingers crossed, toes crossed, before the United States Supreme Court in the Snow-Bianchi case, hopefully coming out this spring. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the 4 Box of Downer, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon. All right, so we had a major oral argument. Just to step back a second, the state of Connecticut enacted effectively an AR-15 style firearm ban on rifles and the like. That was challenged by the National Association of Gun Rights, a powerful organization. Very good lawyer Barry Arrington was handling this case and argued it before the U.S. Court of Appeals for the Second Circuit in New York City. And this was on a preliminary injunction basis, which means this is interlocutory appeal. The lawsuit was brought in the state of Connecticut. The federal district court, which is a federal trial judge, denied the motion for preliminary injunction, got the law all wrong. No shock there. It happens in the Second Circuit all the time in many courts. Then they go up to the U.S. Court of Appeals for the Second Circuit, and that was argued this week. Major argument. Excellent job by Barry Arrington in support of the Second Amendment. I actually thought that some of the judges really gave some grief to the government attorney that was arguing in favor of the quote-unquote assault weapon ban for Connecticut and asked some okay questions. Now, overall, I suspect we're going to lose. It's just the nature of these judges in the Second Circuit. Now, I want to make one observation about this. I think the United States Court of Appeals for the Second Circuit in New York City is a classic example of even when you have judges that basically just try to get the law right. And I think there's actually a lot of judges in the Second Circuit that are sort of politically agnostic on a lot of issues. I think that most of what we see in the Second Circuit, I'm quite familiar with it because obviously, you know, I know people on the Second Circuit. I know people that get elevated to the Second Circuit. It's New York City and the like. I think a lot of the people that get elevated to the U.S. Court of Appeals for the Second Circuit are really business, finance guys. They're out of Wall Street, familiarity with things like commercial debt refinancings, trust indenture litigation, hedge funds, private equity, and the like. And the reason why I point this out is I think a lot of these judges are actually pretty smart and just want to follow the law and get it right. But this goes back to the problem I've talked about before, which is a lot of federal judges, even when they try to get the law right, have two separate but related problems when it comes to handling Second Amendment cases. And I think we saw that to some degree in this oral argument, which I'll put a link to it down below, see if you disagree with me. In this oral argument advanced by Barry Arrington on behalf of the Second Amendment against the state of Connecticut in this NAGR versus Connecticut case. Specifically, the two problems are, even when judges try to get it right, if they're not like, you know, true anti-gun judges, of which there are many out there, but I don't think the Second Circuit is full of them. I think they're just have the two problems I'm about to describe. The first problem is a entirely lack of familiarity with firearms technology. These are people, I know many of these people, they've gone to elite schools from high school all the way up through law school. They did federal clerkships, elite law firms in New York City or Chicago or whatever, and they never had exposure to firearms at all. Even if they're like firearms or conceptually are okay with firearms, they have no familiarity, which means they're very susceptible to being duped or confused about semi-automatic firearms versus automatic firearms, of what is a barrel shroud versus a muzzle shroud, a protruding pistol grip. These things to them are like confusing because they have no experience to understand that a firearm at the end of the day is really just a glorified instrument. It's like a hammer or a wrench with a particular purpose. That's the first issue. The second thing is these judges in the Second Circuit do not see a lot of Second Amendment cases, and that is particularly problematic. Why? Because they see breach of contract cases, they see finance problems, they see Wall Street cases, they say, you know, issues involving the 1940 Act dealing with the regulation of mutual funds. They see these things, they know these things, they live and breathe that stuff, okay? They get it, the law that applies to these kinds of problems that might arise from a commercial fight. but they don't see a lot of Second Amendment cases. As a consequence, again, they're really often learning the law, and when they're trying to learn this law, the anti-gunners are trying to dupe them, in my view, and that is a problem. So again, you have the combination of these judges, even when they're trying to get it right, don't understand firearms technology, so they can screw that up. They don't understand what they're talking about, and at the same time, they don't see a lot of Second Amendment cases, which means they don't even understand the law they have to apply, and that's why you have a lot of confusion. And I think we saw evidence of that during this oral argument in the National Association for Gun Rights case out of Connecticut. Why? Because if you look at some of the questions being asked. So let's just go through some of the questions and answers and discuss what happened during this oral argument. There's a very interesting question here. There seems to be this disconnect between what is the in common use test and how it works. And I actually think that the attorney Barry Arrington did a good job. But let me just break it down so everyone understands. It's not that complicated. In the United States Supreme Court decision of Heller in 2008, right, they basically did the text first, burden shifting to the government to look for historical analog laws to figure out if there's a long-standing tradition in American life, going back to the founding, that would justify some sort of a gun ban. Because remember, Heller was all about whether or not the District of Columbia's gun ban, handgun ban, was constitutional under the Second Amendment. The Supreme Court said it was not. Why? Because obviously the text is implicated, because a handgun is a type of arm, and thus banning a type of arm infringes upon, it hinders the ability to keep, which means to possess, and the right to bear, which means to carry, a handgun, which means your right to have a gun and to carry a gun is being hindered and thus infringed upon. So textually, that means the presumption is there is a constitutional problem that's probably going to mean the law is invalid under the Heller. Then the burden shifts to the government, and the government can come forth with historical analog laws. And the Supreme Court did all this work in the context of, is there a historical tradition for banning a category of arms in the United States? And the only tradition they identified, and then we'll break it down as to how it was back and forth in this oral argument, the only tradition that was identified was that there's a tradition, arguably, of banning weapons that are dangerous and unusual, conjunctive. Now, what's interesting during this oral argument, there was a little bit of games being played, it looked like, by the judges and the Connecticut lawyer a little bit, pointing out that the language in Heller refers to, meaning when you cite to one of the cites to Blackstone, because the Supreme Court relied on a series of scholars, including William Blackstone, an English commentator, and in his commentaries, I should say, he discusses weapons that are dangerous or unusual, disjunctive, meaning it could be dangerous or unusual. But that doesn't matter, because if you look at what the U.S. Supreme Court actually wrote, which is the binding law, William Blackstone may be persuasive to the U.S. Supreme Court, but the Supreme Court is binding law on the Second Circuit. It specifically says that the only time you can conceivably ban an arm is arms that are dangerous and unusual. And obviously, if something is in common use, it cannot be banned. And that was, I think, that came across clearly. That was the argument made by the National Association for Gun Rights in a very powerful way by Barry Arrington in this oral argument. Now, just to step back for a second, the reason why we just went through that text first and history second point of view is this is really goes to one of the arguments that was discussed during the oral argument, which is kind of where does the burden shift, meaning where is the burden to show in common use? And this is often screwed up by judges. And here's an example where I can see the Second Circuit screwing this up because they are not familiar with the law. Step back and think about this for just 1 second. The text says anything that can be used offensively or defensively is an arm. Obviously, a handgun in Heller, and in the Connecticut case we're talking about here, a rifle is an arm because it can be used offensively or defensively, so it's an arm. So we know that textually, the Connecticut law that's being thought about right now is implicated or implicates the text of the Second Amendment, which means the burden shifts to the government. Now, remember I just explained to you that in Heller, the Supreme Court did all the historical work and they looked at the historical analog laws to see if there's a basis for banning a category of arms. And they, after doing that analysis, they came up with a general theory. This is, if an arm is dangerous and unusual, maybe it can be banned. But if it's in common use, it cannot be unusual and thus it cannot be banned. That standard of in common use, if you will, arises from what? It arises from, and this is very important to understand this, and I think the judges were struggling with this during this oral argument. The in common use test is derived from history, from the historical analog portion of the text first, history part second, right? And because the in common use test derives itself from the dangerous and unusual principle all of which comes out of history, as the Heller case points out. What does that mean? Because you're at the historical level of the Second Amendment analysis, it means the burden is on the government. Hear what I just said? The burden is on the government to show that they can ban a particular kind of firearm. So in this Connecticut case, the burden is on the state of Connecticut to show that the types of semi-automatic arms, the types of semi-automatic rifles they're trying to ban and have banned and restricted, they are not in common use. Do you hear what I just said? The government of Connecticut bears the burden to show that these types of arms, these semi-automatic rifles, are not in common use. The Second Amendment plaintiffs literally don't have to do anything. But there's no dispute, really, that these are in common use. There's tens of millions of semi-automatic rifles in the United States and AR-15 style firearms. There's like literally no dispute. And because they're at this number, they're clearly in common use. Now, if you look at what's going on in this Connecticut case, there's this back and forth trying to debate the in common use test. Like, it doesn't seem right. It doesn't matter what the Second Circuit thinks, because their job as an inferior court under Article 3 is to apply the law given to them by the U.S. Supreme Court. But what's going on here, you can tell from the judges in the Second Circuit case, they're trying to figure out what is the law. But all they have to do is read Heller, which is a gun ban case that is good law, that was reaffirmed in no fewer than 80 some odd instances in Bruin to say Heller is the law of the land. All they need to do is apply Heller, ask the state of Connecticut, are these semi-automatic rifles not in common use? Can you show they're not in common use? Connecticut obviously cannot do that. They basically are going to have to concede, which I think they did, that these are in common use. There are tens of millions of these. That's clearly in common use. So any of these ticky-tack attacks on the test set forth by the Supreme Court in Heller is irrelevant, because it doesn't matter at the end of the day what I think the law should be. It doesn't matter what the Second Circuit thinks what the law should be, when the U.S. Supreme Court has already come out with a binding, clear precedent, which they did in Heller. So we should win this case. But again, I think what's going to happen here is that the Second Circuit is going to write some goofy decision where they're going to get some of this right and some of this wrong and simply rule in favor of the government. Because one of the other issues we see is, even if you're a conservative Republican nominee as a general matter on the U.S. Court of Appeals for the Second Circuit, because you have to be vetted by all these sort of anti-gun liberal senators, Chuck Schumer, Kristen Gillibrand, the crazy senators from Connecticut, you see what I'm saying? These are all Vermont, Bernie Sanders. So you got all these terrible anti-gun type, senators in the Second Circuit vetting judges. So the only people that get on the Second Circuit are those that either have no Second Amendment perspective or an anti-Second Amendment perspective. So I think that's why the government's going to win this case on a preliminary injunction basis. But of course, all this should become moot if the Supreme Court takes the Bianchi-Snope case, which we will find out either in late December, early January. And if they grant cert in that case, all this is going to get cleared up, because if the Supreme Court takes the Snope-Bianchi case, it's my view that we are 99.5% chance going to win on that case, that AR-style firearms, AK-style firearms, if they're semi-automatic rifles, cannot be banned by governments in the United States of America, because they're commonly owned. And again, remember, don't confuse what's necessary to win versus what's sufficient to win. The reason why I say that is the in common use test is excellent for the Second Amendment. Why? Because it gives us one, but not the only. Hear what I just said? One way, but not the only way for us to protect our arms. What I mean by that is the Supreme Court says that if an arm is in common use by Americans for lawful purposes, it cannot be banned. That's not the only basis upon which a gun ban law can be challenged and we can prevail on. But it is the easiest way when you're dealing with semi-automatic rifles they're trying to ban, AR-15s, AK-47s, and magazines that hold more than 10 rounds, and I think even suppressors. It's the easiest way to win. So that's it. That's not the only way to win, but it's the easiest way to win. That's why the in common use test, the dangerous, unusual stuff, is actually very good for the Second Amendment. The only other point I want to make about this that came up is there was a discussion, and this is very ironic, that as you recall at the end of Heller, Justice Scalia wrote that if a right finds its way into the Constitution, which the Bill of Rights does, including the right to keep and bear arms, it cannot be taken away from Americans through the democratic process, because it basically has been elevated above the democratic process, which makes us a constitutional republic and not just a pure democracy, because a pure democracy, as you know, is two wolves and a sheep voting on what to have for dinner. So the founding fathers did not want a pure democracy. They wanted a constitutional republic with certain items to be removed from the power of governments to be able to infringe upon, including the right to keep and bear arms. Now, the reason why I bring this up is that there was a discussion about hunting, because the Connecticut lawyer was trying to argue that the Second Amendment plaintiffs have to show that these AR-15s are in common use for self-defense, and because they can't show that these things get fired in self-defense or brandished in self-defense, they can't prove in common use. But again, remember what I just told you. Because the in common use test arises in the historical portion of the text first, history second, analysis of Heller and Bruin, the burden is actually on the government of Connecticut to show that these weapons are not used. But again, it seems like the judges were not buying this, because one of the judges said to Connecticut, well, police carry guns every day, and they carry guns every day for self-defense. They don't brandish it every day. They don't fire their gun every day. In fact, many people who are police officers go through careers without shooting their gun at all in self-defense, and yet they use it every day in self-defense. So I don't think that argument's going to fly. But then there was a discussion about hunting, and the judges were saying, well, based on your theory that you can only protect arms that are in common use for self-defense, that means they could ban hunting guns. And Connecticut specifically said, and this is kind of amusing, he says that, well, hunting guns are democratically protected. Ha ha ha, right? That's ironic, and that's actually an oxymoron, I would say. Democratically protected, even if they're not constitutionally protected, because he said they're so popular they won't get banned. But you know and I know that AR-15s are more popular than a lot of these, wood grain, wood stock firearms that are out there now, right? This is the difference between the FUDs, if you will, and the tactical community and all that stuff you guys are quite familiar with, and probably better at this stuff than I am. So the bottom line is, the court, clearly, and I read it, was looking a little bit askance at the Connecticut argument that says that hunting rifles cannot be protected by the Second Amendment, but it doesn't matter because people won't vote to ban those. But of course, we know that's absurd because the anti-gunners want to ban all guns, and that's pretty obvious. The Connecticut lawyer was trying to argue that AR-15s are more dangerous than a lot of hunting rifles, in addition to the fact that, hunting rifles will never be banned because they're democratically protected. But there's no such thing as democratically protected, even though they're not constitutionally protected. That's what he's trying to say. They're democratically protected, but not constitutionally protected. That's BS. So now they're trying to suggest that the Second Amendment doesn't even protect hunting rifles. And I don't think the panel was I don't think they believe that. I think they're skeptical of that. And I think that was actually a good point for us. And we'll see what the panel does here. I think they're still going to rule against us, but they got to weave around that. How are hunting rifles not protected under the Second Amendment? And that seemed to be where the state of Connecticut's attorney was going. But then he also indicated, the Connecticut attorney indicated that hunting rifles are less dangerous than AR-15 style firearms. This is obviously absurd. We all know that the caliber of a 5.56 or .223 round in an AR-15 is so small that in many states you can't use it to hunt deer because it's not powerful enough. And of course, a basic .308, I don't need to get into this with you guys, better than I know. .308s and all these are much more powerful rounds and much more dangerous, and hunting rifles are much more dangerous in many instances and many definitions, depending on how you want to measure it with the criteria, than an AR-15. And yet, obviously, this goes back to my point that, it's not clear that either the Connecticut lawyer understood this, as a matter of fact, or the judges are going to get at this, because this conversation we just occurred involving 5.56 round, .223 rounds, and, .308 rounds, and so on and so on, is the sort of thing that the judges will just sort of naturally know, which we do just by being Americans that don't live in the city all the time, if you know what I'm saying, didn't spend all their life in the city. And this is the sort of thing that a judge could screw up and be duped by an argument made by anti-gunners or by a government attorney, because they just don't know the difference between these calibers and what they all mean. So they can be persuaded that an AR-15 is somehow a more dangerous and deadly firearm than, let's say, a higher caliber rifle that you would use to hunt, let's say, bigger game. But again, we'll see how all this plays out. None of this should matter because semi-automatic rifles are clearly protected under the Constitution. Justice Brett Kavanaugh made this powerful point in his dissent in Heller 2, which is a big reason why I think he got on the U.S. Supreme Court and was picked by Donald Trump. But again, only time will tell. And again, if the Supreme Court takes the Snope case, previously known as Bianchi, all this is going to get fixed, I believe, in our favor. So we really need Donald Trump to win this election, and we need the Supreme Court to take the Snope case. That's the most important thing that can happen to us, those two things, over the next 90 days to protect our right to keep and bear arms in the United States. All right, folks, hope you learned something here today. Make sure you follow me on X at 4 Boxes Diner, and we will see you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.